Hey everyone, we are back for part 4 of the Owens v. Echard deep dive into the case. For those of you who aren't familiar with the case, I have a playlist that I will link in the description. There is an ongoing case in the Maricopa Superior Court. It deals with, it started out as a paternity case. The petitioner, Miss Owens, is no longer pregnant, and now it has turned into a shit show. Welcome. So we left off on timeline part 3 with right at the end of December. And since that time, this is how many motions have been filed between December and the February court hearing that we're trying to get to. So we're going to try and go through these as quickly as possible. I think it's nuts. Absolutely nuts. So the first thing was a motion to quash filed by Miss Owens' attorney. They were saying that she did not need to participate in the deposition. She didn't need to be deposed because she was no longer pregnant. It's no longer a paternity case. There's nothing to discuss. She noted that the respondent would not stipulate to the dismissal, which is what they wanted. They're like, okay, well, she's not pregnant anymore. Let's walk away. Like, Clayton's side's like, like, something went on here. Like, we need to get to the bottom of this. And her attorney's like, but she's no longer pregnant. Let's just go on with our lives. He's like, nope, that doesn't work for me. So Clayton's attorney, Greg Woodnick, had filed a motion to extend the time before the case became inactive. It was on the inactive calendar. If it becomes inactive and there's no movement in the case, they're going to close the case and move it on. They're not going to let it just sit open forever with nobody doing anything. And he wanted more time, and he also asked for an evidentiary hearing to be set on the paternity/non-paternity issue, attorney's fees, and the Rule 26 sanctions. Petitioner, which is Laura's attorney, responded and asked that be denied in its entirety. Now, at this point, these were all filed right at the end of December, and I think they weren't actually recorded until January, and Lexi is still her attorney at this point. So the dates that are on here are the dates that the court actually filed these motions. They aren't necessarily the dates that they were submitted to the court. They're when they were published. So Woodnick filed a motion for sanctions pursuant to Rule 26, and that would be against Owens. However, that was subsequently withdrawn. There is a lot of controversy over this because the court did not enter the judgment order accepting the withdrawal right after it happened. There was a clerical error, and it went on until, I think, last month when they finally entered it in. So a lot of discussion happened about the Rule 26 sanctions when that was not on the table. As part of this flurry of motions that are all pretty much saying the same thing, one stands out above the rest as being just freaking amazing. And that is Mr. Woodnick's response/objection to petitioner's motion to dismiss petition to establish paternity legal decision-making, parenting time, and child support with prejudice. The petitioner's motion must be denied, as the motion, without any proof that the petitioner was pregnant in the first place, that the petitioner is now without child, is insufficient cause for a dismissal under Rule 29A1. Permitting the petitioner to bring this action, seek out media attention, force the respondent into court to respond to baseless and malicious allegations in 3 different court cases before 3 different Maricopa County Superior Court judges, to then absolve herself by simply claiming without any evidence that she isn't pregnant would be a gross miscarriage of justice. The petitioner continues to demonstrate that she is eager to utilize the media to support her fabricated pregnancy narrative, and she will continue to claim that she is pregnant by respondent unless the court adjudicates this matter with a finding of non-paternity. On or about January 2nd, 2024, the petitioner again contacted the Sun and stated she firmly stands by everything, and she had a positive pregnancy test at one point that confirmed her pregnancy. The current existence of her pregnancy, as explained below, is insufficient cause for a dismissal. An adjudication that she was never pregnant, or at least that she was never pregnant by respondent, is what justice requires. This is important because there was never sufficient evidence presented, and in this case, it has to be clear and convincing evidence. None of the evidence was clear, and it definitely wasn't convincing. It all could be refuted. He goes on to talk about her motions that she filed, including the motion to dismiss, saying it lacks evidentiary support, misstates well-established law and policy surrounding the subject matter jurisdiction, and would deprive Clayton of his basic access to justice after he was involuntarily dragged into court to defend himself. Put plainly, petitioner's motion cannot be granted, and to do so would be to commit grave and clear error. As and for his response/objection, respondent provides the following. Stating that petitioner, quote, is no longer pregnant, unquote, creates evidentiary issues that must be resolved by this court. After repeatedly claiming and insisting that she was 100%, quote, pregnant by respondent in filings, under oath in various court hearings, and in hundreds of social media posts, petitioner cannot be permitted to suddenly claim, without any evidence, that she is no longer pregnant. Critically, petitioner stated under oath, without any medical evidence, that she was 24 weeks pregnant and due on February 14th, 2024, as of November 2nd, 2023. The petitioner appeared in front of Judge Galketis, I don't know how you say her name, via video on October 24th, 2023, with what appeared to be a pregnant stomach, which, upon information and belief, was actually a moon bump or fake stomach to appear pregnant. At this time, petitioner also requested Judge G permit her to show the respondent her stomach to verify she was pregnant, which of course the judge denied. We remember this one. If the petitioner is now alleging that she is no longer pregnant because of a miscarriage, a third trimester abortion, or whatever she is claiming, her motion to dismiss curiously lacks any explanation. She must provide documentation to support the same. A miscarriage this late in an alleged pregnancy would require medical attention, if not full hospitalization, and there would be fetal death certificates filed with the vital records consistent with ARS 36-239, requiring fetal death certificates to be filed within 7 days after the death, where it was past 20 weeks or 350 grams in weight. If she otherwise disposed of twin fetuses, a criminal investigation would be warranted to locate the remains. Petitioner must provide respondent and this court with evidence to support the existence and now non-existence of a pregnancy. Yeah. It's illegal to just dispose of human remains. You have to follow the proper channels. It's also illegal to possess them in some areas. We talked about this in a prior stream. Petitioner's ability to provide this evidence or any evidence that complies with Rule 2 is highly dubious, and any testimony she provides should be carefully assessed, as petitioner is entirely lacking in credibility. Ooh, ouch. As outlined in respondent's pending pleadings, petitioner has provided no verifiable medical evidence to support her claim that she was ever pregnant. Instead, petitioner offered unverifiable screenshots of appointments, positive HCG tests, a sonogram video taken from a 7-year-old YouTube video, and a demonstratively fabricated sonogram. Wow. Out of 3 fetal DNA tests, 2 have come back showing little to no fetal DNA. 1 was allegedly lost in transit. A conclusive paternity determination has now been made impossible as petitioner refused to comply with a 4th test and ostensibly has determined that stating she is no longer pregnant will allow her to evade the paternity issue and continue to perpetuate the false narrative that she was pregnant by the respondent. See petitioner's December 8th, 2023 Medium article. See also respondent's expedited motion to extend dismissal date. The court must be provided with concrete and verifiable evidence to establish this critical fact to determine whether or not to go forward. Without belaboring the point, petitioner has not provided any rule disclosures, yada, yada. She refuses to sign a simple HIPAA form to permit the release of her records for various medical professionals that she claimed under oath that she was being seen for her high-risk pregnancy. She now seeks to have that action she filed dismissed by claiming she is no longer pregnant, still without any evidence to support the claim. This cannot be permitted. To properly resolve this action, petitioner must prove with evidence in compliance with Rule 2 that the petitioner curiously invoked, despite never providing any verifiable evidence to any court, that she was pregnant due to conduct on May 20th, 2023. Number 2, that she was pregnant with respondent's twins through records held by Ravgen, which respondent is requesting this court order be released, and 3, that she is no longer pregnant with medical records confirming the date and week of gestation that pregnancy was terminated. He goes on to say subject matter jurisdiction attached when the petitioner filed her verified petition on August 1st, 2023. Does anybody else get like a weird feeling when they say subject matter jurisdiction, like almost like a PTSD type vibe? Ooh. The Rule 9C requirement for Rule 26 sanctions has been met, or if the court determines it has not been met, compliance with Rule 9C would have been futile. So basically, he is refuting the argument that there's an issue because they didn't meet in person or by phone to verbally try and discuss and resolve this issue. And that is because Clayton has asserted since the very beginning that there is nothing to resolve because he didn't believe that she was pregnant. And he goes on to reiterate that she has at least 13 different phone numbers leading to over 500 plus text messages and emails threatening to take him to court if he didn't speak to her. Judge G affirmed these communications were harassment and served no legitimate purpose, as he had made it clear he did not want to engage. That's when she granted his OOP. This is great. Put plainly, all of respondents' attempts to resolve this issue by explaining to a harassing and emotionally volatile pro per that she cannot, in good faith, file a petition to establish that she was not pregnant by him went unrecognized. Harassing and emotionally volatile. So pro per, for anybody who doesn't know, is the same as pro se, and it basically means self-represented. You don't have an attorney representing you. You have no legal representation. He offered to meet her in person in a public location, which we've seen messages that said that, and she rejected that. She wanted to meet privately. He paid for and engaged in 3 different paternity tests to further disprove the possibility in the hopes that medical science would resolve the issue. Nothing would deter her, not even 2 DNA tests showing little to no fetal DNA. He has more than complied with that. These text messages are hard to read. That's him asking about meeting up with the mediator and her declining. She wanted to meet with him privately. Yeah. She even went so far as to threaten things if he didn't communicate with her. Petitioner's relentless crusade to accuse respondent of impregnating her, lash out at anyone who disagreed with her, made it impossible for respondent to try and explain to her that she was not pregnant by him and could not be. Put plainly, respondent could not guarantee his safety around petitioner, which led to him seeking an injunction against harassment, which was granted. Therefore, Rule 9C either was met long ago or could not have been reasonably complied with. I think that's reasonable. The respondent is entitled to an evidentiary hearing on his request for Rule 26 sanctions and attorney's fees. Petitioner's conduct is precisely the type of litigiousness and malicious prosecution that the Rule 26 seeks to punish, and a separate motion for Rule 26 sanctions is being filed contemporaneously. That's the motion that was withdrawn for some reason. This is not an abstract question that renders the matter moot, as petitioner claims. Petitioner has been steadfast in her insistence that she is 100%, quote-unquote, pregnant, despite offering no verifiable medical evidence. He says that Clayton is entitled to reasonable attorney's fees, which is absolutely true. I love that he throws in here, petitioner has a history of fabricating pregnancies and reasons for why she all of a sudden is not pregnant. Petitioner acted unreasonably, if not diabolically, in bringing this baseless petition to establish, despite knowing she was not and could not be pregnant by respondent. And respondent has incurred attorney's fees as a result. Again, this is a pattern of behavior that has occurred in prior litigation with other men. And the petitioner shows no sign of stopping. As further demonstration of her unreasonableness and for the sole purpose of attorney's fees, petitioner refused to sign a stipulation to dismiss this action, as she claimed that stating she was never pregnant by respondent would be her committing perjury, Exhibit 5. It is frankly astounding that petitioner is now concerned with perjury after repeatedly perjuring herself in 3 different court cases, and despite the only evidence of paternity showing little to no fetal DNA. This is email communication between, I believe it's Woodnick and I'm not sure which attorney at the time, where he's basically saying, here is something she can sign that will resolve this, and I believe it had some stipulations to it, and they responded that she is not willing to commit perjury by signing the affidavit you sent over. The court will not be able to order her to sign it. She concedes she is not pregnant. There cannot be a finding of non-paternity for a non-existent child. Clayton's only viable claim at this point is for attorney's fees. If he insists on proceeding with a deposition when a motion to dismiss is pending, he's racking up needless fees. Clayton asked the court to deny the motion to dismiss and issue an order declaring respondent was not the father of any children carried by the petitioner. That order by a court would prevent her from being able to claim that he was. And it ended somehow, some way, for whatever story she provided. He also was asking for documents related to it. That this motion sums up everything that happened so well that should have been the end of it. Like, here it is. Like, okay, you're done. Walk away, sister. Like, there's nothing left to fight. Like, admit it, apologize, move on with your life. But did that happen? Of course not. There was the reply that this is a paternity establishment case. The petitioner is no longer pregnant. There's nothing left to adjudicate. Dismiss it and move on. And that's basically all that's said. There's nothing left to resolve. This one is interesting. It says that Clayton would not have had any attorney's fees if he had allowed the case to be dismissed. So a motion for confidentiality and protective order to keep the information in the case private was filed. Ms. Owens' attorney withdrew. That was Alexis Linville. And a new attorney was brought in. She again missed her deposition. She failed to appear for the deposition as scheduled. There were a couple more motions back and forth regarding sanctions and objections, and then the court weighed in at the end of January. The court responded and granted Woodnick's motion asking for an evidentiary hearing. It was scheduled for February 27th at 4 p.m., and we'll watch that in just a moment. So another argument that was made was that evidence was not being disclosed by the petitioner, Laura Owens. One of her arguments was that every piece of evidence that she provided was being immediately sent to the media with the intent to further embarrass her. So she was asking for a protective order to prohibit him from speaking to the public. She noted his little Reddit army. So apparently there were some people on Reddit that harassed her a bit, sending her some not nice text messages, and several people, they say prank welfare checks, called in welfare checks for her. I mean, they could have been legitimate. I would be worried. So Corey Keith is the new attorney who is handling her case at this point. The judge reviewed that order relatively quickly and denied it in response to the argument that Clayton would have not incurred the attorney's fees had he agreed to dismiss the case. Attorney Woodnick responds that had the petitioner disclosed non-confidential and uncontroversial evidence, as well as the statutorily required fetal death certificates affirming things, this wouldn't be a problem. Woodnick brings up again that she refused to meet with him if he did not agree to her bizarre request to date and explore intimacy. He attached the exhibit. Petitioner bringing this entire action knowing that she was not and could not be pregnant by the respondent is the conduct that violates Rule 26B. That the petitioner is now claiming that she was somehow not given notice of her sanctionable conduct is patently absurd, as conveyed to her directly by the respondent through the respondent's granted injunction against harassment and through 3 paternity tests and through counsel. Petitioner's filing was based on fiction. This is not an instance where the petitioner may have mistakenly alleged something that needed to be corrected through an amended filing. This is a uniquely disturbing case where the petitioner expended judicial resources to fabricate a pregnancy narrative to force respondent into a relationship with her, invited media attention, and is now desperately grasping at procedural straws to evade providing simple and uncontroversial disclosure like a government certificate confirming the alleged miscarriage. Boom, mic drop. All of petitioner's filings arguably violate Rule 26B. Her underlying petition, the original filing, was filed without merit and for the sole purpose of coercing Clayton into dating her. Every filing in this action was done for, quote, improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Includes claims that are frivolous and unwarranted by existing law and entirely lacking in evidentiary support, and contains factual contentions that are unwarranted based on the evidence. Yep. I mean, I don't know, like, how much more black and white it can get at this point. All the petitioner needed to do was sign a basic HIPAA form allowing her records to be released, or sign a form to permit Arizona Vital Records to release death certificates to confirm that this happened. She refused to do any of that. Petitioner wanting to be pregnant and being pregnant are 2 different things. Despite her assertions, positive HCG tests are not verifiable medical evidence of pregnancy. This is basically what we went through in the other one. Like, it's not possible. Like the other video, it's not possible. It doesn't. Your body doesn't work that way. It's, there's scientific proof and well-established things that go on that say that this is not possible. Petitioner's behavior in this litigation is unreasonable and predicated on bad faith such that respondent should be entitled to his reasonable attorney's fees costs pursuant to ARS 25-324, and so much more. Petitioner's baseless allegations that respondent is using the court as a public stunt and that he is leaking information serve no purpose other than to deflect from her own culpable actions. Boom! She initiated this to hurt him. That's it. Respondent has had to rely on community support to defend himself against petitioner's meritless claims and to prevent her from making another TEDx talk to claim that she was somehow cyberbullied into a miscarriage. Respondent continues to incur significant attorney's fees and costs because petitioner's unreasonable conduct. Yep, makes sense to me. The entire action by the petitioner is predicated on fraud upon this court. Petitioner continues to seek out media attention and exhaust all her procedural remedies to evade basic discovery and disclosure obligations. Perhaps if petitioner provided the statutorily required fetal death certificate and verifiable medical records to support she was ever pregnant with twins, she would look less like, as stated by petitioner's attorney, a crazed woman who fabricated pregnancy. You know, if the shoe fits. So he asked again for sanctions and attorney's fees and other such relief as the court sees fit. These are the text messages from May 25th. Like, there is no possible way for her to have any idea that she was pregnant. She was just, foreshadowing. Is that what it is? Premonitioning? I don't know. Whatever the word is. It's like she knew that this was going to happen and started talking about it on the 25th. That's impossible. And then got mad at him for not supporting her. This finally brings us to the February hearing.
So we used to spend like tonight for the 2-bedroom. That's no. This is a nephew.
Always different. Always. Well, that's fine. Yeah. So Cal.
Travel sucks when you have to go to the same place.
Yeah.
It's the worst.
At least with California, it's nice because I can just drive.
Yeah.
So,
Yeah. And the weather's always good. Usually.
especially in the summer.
Yeah. Like, can I travel for 2
I'm
months?
like, exactly.
All right. Seated, please. Good morning, everyone. This is the time set in FC 2023-052-114. Appearances, please. Beginning first with Petitioner's Counsel.
Morning, Your Honor. Corey Keith appearing on behalf of Petitioner Laura Owens. Myself and client are both present, appearing in person.
Good morning to you both, and from the respondent.
Good morning, Judge. Greg Woodnick. I've got Clayton Echard with me, and my associate Isabel Rani is behind me.
Good morning to all three of you. All right, this is the time set for status conference. As the parties both know, a motion to continue was filed. Mr. Woodnick, that was your motion, so I'll allow you to go first.
Judge, thank you. As the court is aware from the meetings, we have zero disclosure, and I don't think zero is an understatement. I did speak with counsel in the hallway. He indicated that disclosure was forthcoming, maybe as soon as later this week. I'll believe it when I see it, but in any event, we are not prepared to go to trial next week on any of the remaining issues because we have nothing. I'm asking the court to reset the trial for 45, 60 days, whatever the court's availability is, and I'm asking the court to give us 2 hours. Petitioner invoked Rule 2. I'm stuck with it, and I intend to present a case that has foundation for evidence, and her deposition, I think, is scheduled for March 1st if she appears. As Your Honor is aware, petitioner failed to appear at her first deposition setting without leave of court, so I've got to deal with that as well. So we're asking the court just to reset the trial in a couple of months, and hopefully beginning today, there's discovery compliance, and the issues of attorney's fees and sanctions, I think, have to abide trial. And I think that's where we are from our perspective.
Okay, and what time on March 1st, counsel?
Great question, Judge.
8 a.m.
8 a.m.
This morning.
My office.
All right, counsel?
Thank you, Your Honor. Your Honor, we're not opposing the motion to continue the trial. We're in agreement with the need for the continuance on the trial, I did want to address, we received a ruling regarding our motion for confidentiality this morning. There has been new evidence, threats to my client's life that were made to her on Facebook since the pleading practice regarding the motion practice regarding that motion for confidentiality. So I did want to have the opportunity to address that with the court, assuming that the court's position still remains the same with regards to that motion. I did indicate to Mr. Woodnick we will have discovery forthcoming by the end of the week with relation to my client's pregnancy records. Discovery has been requested far outside of the scope of what I believe is appropriate, and so I was hoping to be able to address that with the court as well today.
Okay. All right. So we'll deal with the motion to continue first, then we'll deal with re-urging on the confidentiality and the discovery.
Understood.
Any final thoughts, Mr. Woodnick?
No, I certainly have argument on all of the confidentiality issues, and I think Your Honor ruled on it, but I'll save those for later this morning.
All right. All right. The court will grant the motion to continue. The court is going to vacate the hearing. I believe we had set for the 27th. Yes, we're going to vacate the evidentiary hearing set February 27th at 4 p.m. The court will grant the request to extend the hearing time to 2 hours. I wish I could accommodate 45 to 60 days. We're setting out much further than that, which I apologize for. But Layla, what's our first available 2-hour setting?
It's going to be June 10th, Your Honor, at 8:45.
All right, everyone check your calendar and see if that works. That would be in person again.
And to confirm, that was 8:45 a.m.
Yes.
I do that because I generally meet with counsel back in chambers for the first 15 minutes, but I don't want that to interrupt any testimony time. So that's why I said it then.
Understood. And that date and time works for me, Your Honor.
All right. Does that work for you, ma'am?
Yes.
Okay. Counsel?
Make it work, Judge.
Sir, does that work for you?
Yes.
Okay. All right. So we'll set that then for June 10th at 8:45. Now, with regards to the re-urging of the confidentiality motion, counsel?
Your Honor, my client received Facebook messages on February 7th. Prefer not to read them out loud. I did show them to opposing counsel. I'm happy to show them to Your Honor as well.
Okay.
The conduct has just gotten increasingly more concerning from the public. There almost appears to be some sort of obsession with this case. And I think my client, rightfully so, has been nervous to participate in things like the deposition or giving up her privileged medical records because of this increasingly concerning conduct. Your Honor, can I approach? And
Sure. Mr. Woodnick, you've seen these?
Sure.
Your Honor, I know that our reply mentioned voicemails and things of that nature that my client had received. Nothing directly threatening her life at that point, but obviously after the motions and reply were filed, we started to receive these messages, and so she's just concerned that things are going to continue to progress. And Your Honor, I'll just note as well, the person who's referenced underneath the comment that was made is my client's mother. And then I think they're trying to send over her identifying information as well, some sort of insinuation that they know where she lives and things of that nature.
Thank you. Okay, counsel, I'll let you come and retrieve those. Counsel response?
Judge, a couple of things. Number one, in correspondence to Mr. Keith, I asked for some of the foundational information from that. Whoever wrote what they wrote on that, allegedly to Miss Owens, is not my client. He didn't do it. He's not involved in it. So I appreciate that that's not the suggestion here. Whoever wrote that, it's inappropriate, but certainly not a reason to enter confidentiality orders or any sort of sealing, which I assume is going to be members next in the court, that these are both public figures. And I think that the First Amendment doesn't have.
Anyone who might be mind, please mute your phone or your tablet. Go ahead, counsel.
These are both. Yeah. My ADD does not do well with those noises. Thank you. Judge, these are public people. My client wasn't behind whatever that text was. Frankly, there's a level of incredulity regarding that. I'm not so sure that that text is actually real and it wasn't generated to create an argument to seal or for the confidentiality issue. I can tell Your Honor that we're going to treat Ms. Owens' records if she by them. In this case, it's now 7 months along as we are supposed to pursuant to the rules. Just like I'm going to treat her as we're supposed to when I depose her in 2 weeks. But I certainly don't think that some random Bachelor fan maybe put a really inappropriate text to Miss Owens maybe is warrant for the court to do anything other than remind everyone to act professionally, which has always been my intention.
Thank you. Final thoughts?
I agree with Mr. Woodnick in part. This isn't his client, in my opinion, that's making these statements. However, when you couple the statements that are being made that appear to be getting progressively worse with the instances that were cited in our reply, the civil welfare checks that were sent to her home, the calls to her personal cell phone, when you couple all of these things together and look at the fact that they're getting progressively worse, and my client is now being essentially compelled to produce documents pertaining to her medical history, we don't anticipate this getting better, Your Honor, and my concern is that as this continues to get worse, we start to continue to talk about the safety of the parties involved. I understand that we're talking about public figures to an extent. My client has taken a significant step back. I don't know if, in my opinion, I would classify her as a public figure. She maybe is making statements now to try to defend herself and defend her name. But, Your Honor, my concern is that if this continues to worsen, and like I stated in my response, we don't know what state it's going to get to. We also have witnesses that are afraid to come forward to testify on my client's behalf because they're afraid of what's happening to my client and her family. And so for those reasons, we believe that it's worth at least requesting that the court reconsider the ruling on the motion for confidentiality.
Thank you. Okay, the motion to reconsider is denied. However, we will have the minute entry reflect that Arizona, it's ARS Supreme Court ruling 122 is in effect, meaning all media requests must be through the Maricopa County Superior Court. There are statutory requirements that include using audio only for witnesses, fuzzying people's face out, things like that, that could give some assurances of either anonymity or whatever else may become an issue. I agree the court has absolutely no control over what people post online. It is absolutely inappropriate to threaten people generally, so the court doesn't condone that behavior. However, I don't think at this point it rises to the level of designating anything confidential. So I'm going to affirm my prior ruling on that, recognizing that there may be evidence presented at trial that will require certain exhibits be deemed confidential because of their medical nature or addresses or other things. So the parties need to be prepared to tell me which exhibits at trial need to be designated as confidential, and I'm more than happy to do that. Now, counsel, you also said there was an issue with discovery.
Yes, Your Honor. Your Honor, my client understands the court likely in need, based on the recent ruling, for her to disclose things like her medical records pertaining to the pregnancy. It's been mentioned in the pleadings that opposing counsel has requested that she sign HIPAA releases. Opposing counsel has also sent requests for production of documents. Those HIPAA releases request 5 years of her medical records. Under the recent Como ruling back in 2022, we don't believe that that's appropriate. We believe and are asking the court to order that while she should comply with requests for her medical records, it should be pertaining to the pregnancy, the only issue that's outstanding in this case. And on that note, Your Honor, there were two rulings on my client's previous motion to dismiss, one which granted in part and left open the issues of attorney's fees and sanctions, and one which I received yesterday, which just outright denied the motion. And so I just wanted to make sure that we were still only talking about attorney's fees and sanctions. And if that is the case, I believe that my client's medical history pertaining to whether or not she was pregnant in this matter is what would be appropriate and relevant for the court to have testimony on at the upcoming trial.
Okay, before I get to you, counsel, and then obviously you'll have final thoughts to go back to that, the court's intention was to deny the motion to dismiss at this time. So that's the ruling that stands. Mr. Woodnick?
Judge, I appreciate the Como decision, and I appreciate Mr. Keith's argument. The problem is the nexus of our Rule 26 issue, which is that the entire action was filed in bad faith, is not a fishing expedition under Como. Como was designed to stop parties from fishing expeditions. That's not it. We are looking very specifically for the mental health and medical records that would explain why someone would fabricate a pregnancy, why someone would appear in court in front of Judge Gail Ketsis with a 24-week abdomen, tell Judge Gail Ketsis that they were pregnant, and then magically the babies are gone. And I think in order for us to do that, we have a right to get the relevant mental health records and the relevant medical records. And I also remind the court that that does include the fact, as we've pled here, that there's a history of the fabricating behavior. That's actually the nexus of our Rule 26 motion. For Rule 26, which, to make a clear record, is really Arizona Family Court adopting Rule 11, Civil Rule 11, not Mental Health Rule 11, but Civil Rule 11. And it addresses the propriety of filings and the propriety of signing filings that were signed by Ms. Owens directly. And she filed them, and then she filed multiple filings after that. And every single one of those filings made claims and assertions that this court has an absolute authority over. In order for us to defend or produce an argument regarding Rule 26, we need to have those records. We will treat them appropriately. They are not going to be publicly shared for any that we have any intention of doing at this point, but it's going to be part of a very public proceeding because Ms. Owens, as recently as 4 days ago or 3 days ago, published an article about these very issues. She's made it. She's the one who went to the Sun tabloid claiming not just that she was pregnant by Mr. Echard, Judge, but that she was pregnant with twins and posted a visual of the twins that she was pregnant with. We have a right to all of the discovery relevant to that for the attorney's fees issue, for the sanctions issue, and for the integrity of Title 25 and the mud that Mr. Echard's been dragged through. I'm not interested in her childhood trauma. That's not relevant here. I totally agree with that. But Rule 49 does specifically say we're entitled to 5 years of back records, and I think asking them to be produced is reasonable. I also remind the court as my final comment, they've provided nothing. When I say nothing, Judge, I mean no medical records, no financial record. I mean nothing. Even the stuff that is not even controversial, like legal fees, zero disclosure. So to come to court today and say, oh no, we want to rein in the disclosure is a little bit disingenuous. They should have been providing records along the way because that's what Rule 49 required.
Thank you. Counsel, do you recollect when the first filing was that would necessitate records back that far?
Yes, it would be 2021 February.
August 2021.
Okay. Final thoughts, counsel?
Your Honor, just to be clear, discovery has been transmitted, albeit minimally, because my client has been afraid of the backlash that would occur. My client did send Mr. Echard confirmation that she was pregnant. She sent him over the results of her blood testing. She has sent him over documents. I believe that the evidence will show that she was pregnant. I believe that that will be clear once everything is presented to the court. And I don't believe that it would be appropriate for her to have to disclose records dating back to January 1st of 2018, as the respondent is requesting, addressing her anger management, substance abuse, domestic violence, and additional things. This is a fishing expedition. This is what's covered under COMO. The difference is we don't even have this situation under COMO, Your Honor. We have a situation where there is no child. There are no best interests of a child to be considered. We have a situation where the respondent is on a fishing expedition. He's trying to pull things in and twist stories of previous incidents against my client to make it seem like she's fabricating these allegations. When the reality is, and like I said, I believe the evidence will show this, my client was pregnant. She did have a miscarriage. She's no longer pregnant. And I believe that the evidence will show that. And so for those reasons, we're asking the court not to allow this fishing expedition. They're requesting documents dating back to January of 2018. This is absolutely should be covered under COMO, and I believe that the court should actually look at this even further because, like I said, there are no best interests here to evaluate to overrule my client's medical patient privilege. I understand that my client has an obligation to prove her pregnancy, and I think that it's in her best interest to do so as well. But to allow the respondent to go back 5 years into her domestic violence history, her substance abuse history, and obviously assuming that there even is any, it's just absolutely inappropriate. And this is a fishing expedition. Thank you.
You said your client did provide limited disclosure. Did that include evidence of the miscarriage?
No, Your Honor. The miscarriage came further throughout this case, and the records that outline the miscarriage and her going to the doctor after the miscarriage have not yet been sent.
And when are well,
Your Honor, all of my client's medical records pertaining to the pregnancy will be sent to the respondent by the end of the week. I do have them. We were just waiting on a ruling on the motion for confidentiality because we have concerns that by next week they'll be released to the public.
how would they be released to the public, counsel, if they're just exchanged between counsel?
Well, Your Honor, I believe that they would also be sent to the respondent, and I can tell the court that even my own emails to opposing counsel have been, in this case, released to the public. I'm not insinuating that that is Mr. Woodnick. I understand he has an obligation to share the documents with his client, but the reality here is documents that are being transmitted, pleadings that are being filed, emails that are being sent between the parties are being released to the public in a manner of hours, not even days, certainly prior to someone's ability to pull pleadings online. Also of note, those pleadings that are being released to the public are being released in color. I believe it's common knowledge that when you go down to the courthouse and request documents, those documents come back in black and white. So it's clear to me that there's some sort of a leak to the public. It's why we filed our motion for confidentiality, and I don't believe it's appropriate for my client's records dating back to 2018 to be dragged through the public.
All right. When did the miscarriage occur, counsel?
Your Honor, I'm not sure that an exact date is known.
What month?
Your Honor, I believe my client went to the doctor in mid-November, and that's when it was determined that she had a miscarriage. We would believe that it was in the maybe month or 2 months leading up to that time.
So previous counsel should have disclosed that, correct?
Well, Your Honor, I believe that the increasingly concerning nature of this case and the request for confidentiality and the request for the dismissal, I believe that given the fact that everything my client sends to respondent is being shared with the media, I believe that warrants at least some degree of the court finding her actions to be reasonable. She is actually receiving threats to her life, voicemails on her phone. I mean, this is concerning conduct from the public. And so we were just waiting on, same thing with the deposition. I told Mr. Woodnick we would appear for a deposition if the court ordered us to. We just wanted to have the motion to quash and the motion for confidentiality ruled on prior to doing so because we wanted to have the court's input into if those things were necessary.
But counsel, my follow-up question to you then would be, if she had disclosed it in November, wouldn't this case have simply gone away and these issues wouldn't remain?
Well, no, Your Honor, because she did disclose the fact that she had a miscarriage. It's well documented in our pleadings. I understand that the medical record either, but my client does have a patient. She has privileges that in this case are not only being not considered or not fully considered, but it's being taken even further, and her documents are being. I have no doubt that the second we send over that disclosure statement by the end of the week, all of her records will be on Reddit. And so, Your Honor, I don't believe that. I understand where the court is coming from, and I think that had there been some sort of an agreement, we've offered for the documents to be shared between counsel. I've offered for him to come to my office and see the documents, and we've had some discussion about that. Obviously, the recent pleadings, I think, may change that from the court, but it's not us trying to hide the ball. It's us trying to make sure that my client's medical records aren't shared with the entire world.
All right, we'll have the minute I agree reflect that no party is to disclose outside of themselves any medical or other documentation disclosed between the parties. That goes both ways. I don't want anyone releasing any exhibits, medical records, or anything else regarding the other person. And that goes both ways and truthfully should go without saying, but I recognize it does not in this case. I am going to order that the records be disclosed dating back to August of 2020. That's 1 year prior to the first filing. I think that that's appropriate. Mr. Woodnick, do you have a release with you today that she can sign?
I've sent that.
This outlines that it would date back to 2018, so I believe we need to
Redline it. That's fine.
If you'd like to adjust that, and then we can sign that and have that done today.
Okay.
You can do that now.
Judge, on the discovery issue, if I may.
Sure.
I appreciate Your Honor's ruling. Obviously, I'm assuming If there is something that comes out in those records that requires us to seek leave of the court to expand that, we can readdress that with the court. If something is in those records that imagine getting part of a medical record because of the date issue, we'd be able to come back to court and address that if necessary.
Both parties always have that right.
Secondarily, appreciate that Your Honor's not living this case every day, but the testimony, not the testimony, the statement of counsel was just that mother says she had a miscarriage 2 months before November. In November, the parties appeared in front of Judge Gail Ketsis, where mother had a pregnant belly and told Judge Gail Ketsis she was 100% pregnant by my client. Your Honor's not adjudicating that today, but I'm asking Your Honor to take back the protective order proceeding that was granted in my client's favor for purposes of not consolidation, to be heard concurrently for the purposes of attorney's fees and sanctions on that matter. Because if what counsel just said is that she was not pregnant at that time and she lied to Judge Gail Ketsis in that proceeding, then I think that's sanctionable and Your Honor could enter orders under that proceeding. So I'm asking Your Honor to take, not jurisdiction, but to hear that matter concurrently or to have that file available for our upcoming evidentiary hearing.
Response?
Your Honor, I would ask the court to deny that request. Spoken to experts in this case preemptively about this trial. The reality is sometimes people have miscarriages and they don't even know that they miscarried. I'm not saying that that is the circumstance here. I certainly wasn't present. I'm saying that my client has not lied in this case. She has not intentionally lied to the court. Whether or not she was pregnant on that date, I think she could have testified that she was pregnant and she could have had a miscarriage days prior. I don't know, but I believe that the testimony in her deposition, the testimony in her final trial, and the expert testimony that will come with it will make those things clear. I believe it'd be absolutely inappropriate to throw out previous proceedings in this case based on my statement, not even my client's statement. There would need to be an evidentiary hearing in order for that to be proper.
But I think that's what he's asking. He's asking that the evidentiary hearing be wrapped into this.
And Your Honor, that's not appropriate. The evidentiary hearing has already been done. And like I said, my client's statements that were made during that hearing were true to the best of her knowledge. The reality here is sometimes women believe that they're still pregnant when they've had a miscarriage, and they don't know until they go to the doctor that their levels are no longer appropriate for a pregnant woman. I do believe that that is what occurred in this case. Timing-wise, I don't know if any of us will ever be able to tell exactly when that miscarriage took place. But I do know that my client, from our conversations, did testify truthfully, and there were not misstatements that were made there. We're certainly not intending to change her testimony. But like I said, we have spoken to experts that have identified that sort of occurrence does sometimes happen.
Follow-up question to his comments. Counsel, are you asking that I revisit the order against harassment or just for purposes of fees and costs?
Just for purposes of fees and costs, because the order was appropriate that Judge Gail Ketsis entered. However, she did not order fees and costs. I would contend that if she knew what we think the evidence will show, which was that Ms. Owens just lied and said she was 24 weeks pregnant with twins, and then apparently had a miscarriage apparently 2 months earlier, that had she, if any of that is true, that had she known that that was her testimony at the time, she would have ordered attorney's fees in Mr. Echard's favor, and I'd like that to be on the table at the evidentiary hearing.
Okay, so then if I'm hearing you correctly, what you're saying is the separate cause number is, you think, what delineates and prevents the court from awarding fees and costs at our evidentiary hearing in its totality.
I'm not even sure if I'm right about that. I know that the court changed the rules and required us to use different cause numbers. Otherwise, it's the same parties, and it could be the same cause number. But our rules require us to have two separate cause numbers for the protective order proceeding, which has already been granted in this tail end of a paternity matter. I'm just asking that Your Honor treat them as one for purposes of any attorney's fees and sanctions you may choose to order at the upcoming hearing.
All right. Final thoughts on that?
Your Honor, this is a res judicata issue. The issue of attorney's fees pertaining to protective orders and injunctions against harassment have already been litigated. They've already been decided. In my opinion, to the extent, well, one, I do believe that it would inhibit, I believe it's a separate case that would inhibit this court's ability to order fees unless it were to be merged, which I don't believe is appropriate with it already being over. If there were more evidence after our trial that would warrant Mr. Woodnick believing that his client would have been entitled to fees, I believe that he would need to take recourse with that judge in that case number and seek appropriate remedies. I don't believe it's appropriate for the court to reissue something that's already been litigated in anticipation of Mr. Woodnick's assertion that there may be additional evidence that would prove his client's claim. There certainly isn't at this point. There haven't been those things proven at this point. So I'd ask the court to deny the request.
Did either party have an attorney at that hearing?
Yes, Your Honor, I believe both.
Okay. All right. So then what the court is going to do is the court is going to hear evidence and testimony as it applies to sanctions and attorney's fees and costs dating back to the filing of the petition, all pleadings filed within the Maricopa County Superior Court. So everyone's on notice to be prepared to present testimony and evidence on that. Whether I ultimately award anything as it applies to that case, I can't tell you right now because I haven't heard any evidence or testimony. But I'm not going to preclude myself from that option at this point. So we'll have the minute entry reflect it so that it's clear.
Your Honor, if there was, and I wasn't present during those proceedings, but if there was an order denying the request for attorney's fees at that time, is this court setting that order aside?
No, I definitely wouldn't be, but are both parties, I recognize that the court can take full judicial notice of the entire docket of the Maricopa County Superior Court, so I don't need your permission to go look at that case, but I do think I need your permission to go watch the hearing. Do either of you object to me going and watching the hearing?
Absolutely not.
No, Your Honor.
Okay, so we'll have the minute entry reflect that between now and June 10th at 8:45, the court will review the order of harassment hearing. Do we know what date that occurred on?
The hearing dates, it was split in two. There was October 24th, 2023 and November 2nd, 2023.
Thank you. November 2nd,
Yep, that's right.
2023. All right, so the court will review that between now and then, and that'll give me a little bit better idea of what authority, if any, I have. That just wasn't something I was willing to look at until I had the party's permission.
Thank you, Trish.
Thank you, Your Honor.
All right, and then with regards to Mr. Woodnick's request for the DNA testing and the vital records, is that disclosure you intend to present today or by the end of the week, as you talked about earlier?
DNA testing and the vital records, what exactly are you referring to, Your Honor?
If you look at page 14, I believe it was of his response to your motion, it requests the court issue an order compelling Ravegan Inc. to produce all records and documents related to fetal DNA testing in this matter, and subsection D was issue an order compelling Vital Records to produce all records and documents related to fetal death certificates under, and then the appropriate ARS for alleged twin fetuses born to petitioner.
Well, Your Honor, there isn't, to my knowledge, there isn't a vital records record or request that would be able to be produced because there wasn't one. Regarding the DNA testing results, that will be included. So what my client has will be included in our disclosure.
Okay, and when is that forthcoming, today or?
It'd be by the end of the week, Your Honor. I just have to prepare. And just for the record, I believe that Mr. Echard did participate in those with the DNA testing, so I'm not sure why he wouldn't have received those records independently as well.
And obviously, I don't know either, but I did read in your motions that one of the results was lost in the mail, so I don't know how else that was conveyed to anyone, whether it was conveyed or not, I don't know. So recognizing that it may be moot. Yes, Mr. Woodnick?
If you can help us, smarter than the associate whispered in my ear that Jen requested you to release the information. So if Your Honor would be inclined to, since Mother's obviously now cooperating, if Your Honor would be inclined to endorse or include language in there, I'm happy to shepherd it over to RabGen, directing them to produce all records related to any DNA tests taken by or with Mr. Echard and or Ms. Owens in the past 10 months, whatever it's been. That would be our request.
And Your Honor, for the record, I don't have an objection to that. I believe it would be an appropriate disclosure.
Okay, well, go ahead.
The other thing in our request was we had wanted Mother to sign the requisite fetal death certificate, the verification, so we could get those records. I realize Mr. Heath can't testify, but is the position of Mother there will be no fetal death records because none were ever submitted? If that's the case, I'll let the issue go. I'll address it at trial, but him testifying doesn't really cut it on that issue. If not, we need confirmation from the state of Arizona that there are no fetal death certificates.
And Your Honor, that is correct. And on that note, and I haven't addressed this with Mr. Woodnick, but I think it might be appropriate for us to amend our initial petition just for clarity at this point and to make sure that all parties are on the same page with what's being pled. So I would ask the court for leave to amend our position just so that we could make these points clear in anticipation, although I do believe the discovery and her deposition will probably do that to an extent. I believe it's appropriate for us to make that clear in the pleadings as well.
And what are those intended amendments, counsel?
Your Honor, the amendments would be just outlining the new circumstances. Obviously, her petition was filed predating any sort of miscarriage or likely even a lot of the care surrounding the pregnancy. So it would be to make those things more clear. And also, Your Honor, I don't believe there were attorneys at the beginning of the case, so it would be to make sure that we're explicitly requesting attorney's fees as well.
Okay. Don't you think your motion to dismiss addressed that?
Your Honor, I think the motion to dismiss did address that in part, and it did request attorney's fees for the motion to dismiss. But if we're going to request it for the entire case, I believe amending the petition would be appropriate. I also know, I believe the respondent was just allowed to amend his petition a month or two prior. So I don't believe that it would prejudice anyone with us scheduling the trial out so far. I'd have no objection getting it done in a week. And if the court wants to consider our motion to dismiss a request for attorney's fees for the entirety of the case, I would be fine stipulating to that and saving the motion practice as well. And maybe Mr. Woodnick is stipulating to that.
She wants to make, if Your Honor wants to consider her claim for attorney's fees at trial, I have no issue with that. I have an issue with amending a paternity petition, which was perjured, because I don't want to be precluded from addressing the perjurous statements in the paternity petition. If they want to amend it, that's fine, but I'm not ignoring, and nor do I think I have to ignore what was signed and filed with this court originally and then repeatedly prior to us coming here today. And so I don't want to lose that opportunity because Mother all of a sudden realizes that stuff that she put in that petition was not truthful.
Okay. What we'll do is we'll treat the motion to dismiss as a request for attorney's fees and a motion to dismiss. Of course, I'm not minimizing that, but we will note in the minute entry, Lamar, that both sides are seeking attorney's fees and costs. And then the leave to amend based on the argument you've presented today is denied. In the event you need leave to amend for some other reason that doesn't change the alleged facts that were presented back in August, then of course I'm not precluding you from filing a separate motion to amend. I'm just denying your request as it's given to me today.
Understood, Your Honor, if I may. I just want to be clear, my intentions are not to change any of the facts that were originally pled, just to expand on the facts that were originally pled. I just want to make sure I'm clear on that for the record.
I understand. All right. Now, with regards to disclosure, since we're set out now in June and we've got the deposition March 1st, when's an appropriate disclosure deadline? I don't know how much. It sounds like everything maybe still needs to be done, but truthfully, this is not a complex case. It shouldn't take very long.
You're going to have the HIPAA responses, so I guess I'll leave this one too.
So don't know what we're getting, but if we get HIPAA responses, I guess the burden is now on us to take those HIPAA responses and go to the listed doctors that she said. I'm concerned that that's going to take some time. If she's having the HIPAA release today.
Yeah.
Do you have an inventory of what you can disclose now?
Okay. Okay, that's fine. So obviously March 1st is a pivotal day. Why don't we we'll set the disclosure deadline 30 days, Lamar, 30 days before trial. And that is, from any disclosure beyond that deadline will be precluded. However, the parties are to complete initial disclosure no later than 45 days from today's date. So that gives you guys about 30 days after the depo. And then assuming that there may be additional depots that need to be done. Are there any questions about that schedule?
Oh, yeah.
Just my last comment, and appreciate your time. Just so the court's aware, I have every intention of taking this HIPAA release because I sent a bunch of them originally because there's a bunch of doctors that you claim. I'm just going to reproduce it and repopulate it. Is that okay, Corey?
Yeah.
Okay. All right. We'll have the minute entry reflect that Mr. Woodnick has been provided with a amended signed HIPAA release, and counsel agree that he may amend the provider.
And the date as well, Your Honor, because it requested the 19. And I'm worried that they won't accept it with me crossing off the date too.
Do you want me to sign it too? It might help.
I don't know how you want to do this, Judge.
That's okay.
I'll
Right.
defer to you, Your Honor.
So that's fine. We'll just endorse, who are we endorsing, Mr. Wood?
There's, at the protective order hearing, Mother listed 4 physicians that she claimed she was treating her current pregnancy for.
Okay, and I don't want to disclose those today in the hearing because I'm not sure who I have here virtually, but can the parties send a joint email to the court with the names of those doctors? And so that I have a record of it, we will not put it in the minute entry because that is public. We'll just have the minute entry reflect, Lamar, that the court will be provided with 4 additional providers.
I think it's 4. Don't hold me to that.
And Your Honor, I think it'll be more. Just to be clear, I believe it may have been 4 then, but we'll figure out the list.
All right, we'll just have the minute entry cross out 4 and put more than 1. All right. So we've discussed disclosure, we've discussed the deposition, we've discussed all the pending motions. Mr. Woodnick, since this was your motion, is there anything you feel that the court has failed to address?
I think today was very productive. Thank you, Judge.
Thank you, Mr. Keith. Anything the court's failed to address?
I agree, Your Honor. Thank you for the court's time.
You're welcome. All right, everyone, we will stand in recess until June.
All rise.
Oh, counsel, you can come get these back if you want them. You might want to shred them.
All right, so that was part 4. Stay tuned for part 5. I will cover everything up until the June 10th hearing, which will hopefully put an end to this case.